Good afternoon, good morning, good evening. Hi, everybody. This is Lloyd Malik on another edition of the Ask Lloyd series. So one of the things that I've been finding lately, a lot of my clients are coming in and people are asking questions about child custody. There's a lot of problems. There may already be people who are coming in who have a custody agreement in place, and then there's certain changes that are going on in their lives or the lives of their former spouse or former partner, co-parent, if you will. But before I get into some of the more nuanced issues with respect to what has been happening a lot lately in various people's lives, unfortunately, people, even after divorce and even after a custody order, there's still problems. But what happens originally when one is going through a separation, going through a divorce, breaking up with their child's other parent, there will normally be at some point either an agreement or a trial and a finding / judicial order declaring that there are certain child custody arrangements that are part of the order. So you go to trial or you get an agreement, but if you go to trial, the judge is going to look at the standard, what is in the best interest of the child when determining who should get what amount of custody, or who would get legal custody, who would get physical custody, etc. And the difference, there is a big difference between the legal custody of a child and the physical custody of the child. The more complicated is the physical custody because there's so many different arrangements that can be made as far as who sees the children and when they see the children. But the legal custody is who gets to make the major life decisions for the child, such as medical, educational, religious, those types of major decisions. Normally, unless there's some exceptional circumstance, and we can go into that on another Ask Lloyd, the parties will have joint legal custody, but still there'll have to be an arrangement for physical custody. So say we have an example where the parents have 50-50 custody, for example. They live close by, everything's equal, and it's all great. We like to have that. And if the parties could come to an agreement before having the judge rule on that, even better. That would be an ideal scenario in a custody battle. But what we're going to talk about today is what happens when things change. What happens if one spouse or the other has one ex-spouse or the other, or one partner or the other, or if you are in the situation yourself, you or your former partner have a major life change, such as a relocation. This is what's been coming up a lot lately. Somebody decides that, hey, it was great here living in Maryland and DC in this general area, but I got a great job offer in California, and I got these minor kids, and well, I got an ex-spouse over here, but I really got to go and move across country. What are you going to do? How do you decide that? Well, that would be ideal if the two parties could come to some type of agreement. But say it's you and you're deciding that you're going to move. Well, if you get your ex-spouse to agree to that, well, all the power to you. That's fine. You could work out another arrangement where perhaps there would be summertime access, vacations, certain, flying cross country is often a pain in the neck, but there are arrangements that can be made. It's unfortunate that the parties can't stay together in this, for the sake of the children. But again, this is what we're talking about when these situations don't always work out. But what happens if you can't work it out and you're in this position? Well, yeah, I got to move. Well, what do you do? Again, no chance in working it out through, well, I guess you could always try, if you can't work it out yourselves, you could always try mediation. Maybe a mediator could help bridge the gap and there's something that can be done. But if not, and you have to go to court, well, there's some big decisions that the judge is going to have to make. And certainly at this point, to modify a child custody arrangement, the court's got to find two things. First, there's got to be a significant change of circumstances. And I think most courts around here would say that moving across country would be a significant change of circumstances. But what if it wasn't across country? What if it was I don't know, 10 miles, 20 miles, 30 miles, 50 miles, something that would upset the day-to-day routine, 100 miles, it becomes a little bit more complicated at that point. Could you still say if you had 50-50 custody, 1 week on, 1 week off, well, maybe you can do it, but each day, the person who's moving 50 miles away would have to get the child back if they were going to continue the week on, week off. So you could see some complications arising there. But the court would have to look to say, hey, what is in the best interest of the child? And one of the things that's pretty interesting about this is that a person who is moving for like a promotion, that's one thing. I think a court would be able to determine, well, there's something going on here that it may be a good for the child to move, but they may not. And what if the person wants to move to, say, I don't know, move cross country because they found another romantic partner, a new husband or new wife, and they wanted them to move and say, hey, I'm going to move, but I want to take my kid. If you're the one who's left home, how would you feel? Like, no, I don't want my child to move out cross country, or you might be the one who says, yeah, I do want my child to move cross country. These would be the really more complicated types of cases. And again, these are, if you can handle them yourselves, if you could work something out, that's great. But if not, and you have to litigate, that's when you really got to seek the advice and expertise of somebody who is well rehearsed and well practiced in this particular area of law, because there's nothing certain. There's no certainty. There's no guarantee what a judge is going to do. It's not a sure bet that you're going to get it. And again, it's nothing that anybody would really want to go through. Having gone through, in our scenario, a high conflict divorce to getting to this point and then trying to change it, it brings back, it'll just reignite that fire that nobody really wants to endure. But again, this is what is going on in a lot of people's lives here in our community. And if you or anyone are going through this or thinking about this, and you don't really know what to do, where to turn, best advice I can give to anyone who's listening to this, and this is not legal advice per se, but it is advice, that would be to go seek legal advice from a lawyer who is experienced in this particular area of law. And this is something that you definitely do not necessarily want to go at it alone, because what may happen is, say you do, and you say, you know what, yeah, there's a court order, I really don't care, I'm going to just take the law into my own hands, and I'm going to move across the country, be damned with the order, be damned with my ex, I'm going. Well, one of the things that you would certainly want to know is that you may be subjecting yourselves to potential contempt, because in our scenario where you have, say, 50-50 custody, you could no longer maintain the order. You would be interfering with the order by not allowing, or by putting the child in a position where they could not go back and forth every week, for example. So what happens if that is your situation? Well, and you do it, and the person who does not leave files for contempt that you violated the order, well, the judge may find that there's contempt and order that you come back, or say, well, if you find it more important just to leave, to deprive the child of their other parent for your own interest, whatever it may be, whether it be a new marriage, whether it be a new job, but without the consent and without the violation, and in violation of the order, it may turn out that you'll lose custody by doing it. So that would be a very, very risky endeavor. Not to say that people haven't done that, but that is definitely something that one would be cautioned against doing. But if you find yourself in that scenario where your ex-spouse, your child's other parent, is indicating that they're going to move, or you want to move, please, most important thing is you can do, seek out the legal counsel that you need for this particular scenario. And with that, I just want to say that being part of this organization where I am providing legal services to people, the firm is growing. We're having more and more successes, and we are just happy to let everyone know that please give us a call here at Malik Law, and we will certainly help you with whatever your family law issue may be. Thanks very much, and I look forward to talking to you next time.